today. Please state your name for the record, sir.
Hi, this is William Ellis.
Okay, hold on. And we're going out 3 weeks. Is this a probable cause conference?
Today is set for the probable cause conference, yes.
What's the status of discovery?
We are still awaiting digital discovery. Prosecutor doesn't have it, but she indicated she should be able to get it by the 8/25 exam date.
We're going outside of the 21 days if we set this for August 25th.
Yes, Your Honor. We looked at the date prior to the 25th. However, I'll be in trial all week. And so the 25th was the next feasible date.
Okay, is your client waiving the 21-day rule?
Yes, Your Honor.
All right. Mr. Ellis, you understand you have a right to have your preliminary examination within 21 days of the date of arraignment?
Yes.
And are you waiving your right to have that exam within 21 days so your attorney can receive video and prepare?
Yes.
Okay, I find the waiver knowing and voluntary. I'll see everyone back in person August 24th at 10:30 a.m. Bond will continue.
August 25th, I think the 24th is a Sunday.
Oh, wait, can I see that file? I think I'm giving you a Sunday date. Maybe I wrote it. August 25th. All right.
Thank you, Your Honor.
All right, have a good day. Thank you.
You as well. Miss Ellis, you can log off. I'll be in contact.
All right.
All
Thank
right.
you.
Thank you. Do I have the jail in here on Henderson-Gross? Miss Donna, have you seen your client?
I don't see her, but I would waive her appearance for purposes of this hearing since I'm asking for a competency evaluation.
All right, well, she is here, so I'm gonna bring her in.
Okay.
All right, this is 252192FY, the people versus Jay Shanish, Gail Henderson-Gross. Miss Johnson, can I get your appearance? Oh, Miss Johnson is at Third Circuit, in the middle of a hearing. So I need to give her a second.
Okay.
I have this file up here for Jacqueline. Wait a minute. Here on this, I have Jones, the attorney never came back in on, right? Yeah. Wittenhoff and Coleman. Miss Louie, I want to go over with you before you leave. Counsel,
Yes, Your Honor. I want to make a record. I'm asking for a dismissal at this point. I mean, this is the pre-scheduled time for a preliminary exam that was confirmed with the prosecution. The prosecution is not ready to proceed against Mr. Jones today. I don't think Mr. Jones should be required to keep waiting for the prosecutors to become ready. The proper remedy, I believe, at this point would be dismissal without prejudice, and this case could be refiled if the prosecutors saw fit.
okay, it's the prosecutor's first request for an adjournment. Mr. Jones is not in custody. There's no unfair or prejudice, and it's a simple 1 week request, so I'm granting this first adjournment request. And she's requesting a date of August 11th.
Your Honor, my problem with the scheduling is that this was going to be my last Monday available for quite some time. I'm about to leave on kind of my only long trip out of state with my family. I'm returning. My first day back is the Monday, the 25th, but I start a jury trial that day with Judge John Gillis. So I'm really not available to do this exam until the first week of September.
I mean, I don't know what I can do other than that. If she dismisses and reissues, we'll be at the same point. So can you do 1 o'clock on 9/3?
9/3, 1 p.m. I can definitely do that.
All right, bond continues. I find good cause based on prosecutors, witness and defense counsel's vacation, defendants out of custody. So we'll see everyone September 3rd at 1 p.m.
Thank you, Judge. That's a Wednesday, right?
Is it because of the holiday? Yes.
All right. Thank you, Judge. We'll be there.
All right, thank you. And now, Ms. Johnson, as soon as you're ready, let us know. Oh,
Ready, Judge. Thank you so much.
ready. All right, this is 252192 FY, the People versus J. Shanice Gale Henderson-Gross. Can I get your appearance?
Good morning, Your Honor. Brittany Johnson on behalf of the people, B83513.
Now I don't have her attorney. Let me see if she's in a breakout room or if she got disconnected. All right, we've lost her on Zoom. My understanding was she was referring for competency. Is that your understanding as well, counsel?
That would be my understanding based on what I reviewed when I signed the warrant, Judge.
All right, so I'm gonna review it. We'll refer it for competency. And if her attorney comes back on, Ms. Johnson, I'll just advise her of that as well.
No
Okay.
problem, Judge. Thank you.
All right, thank you. Ms. Henderson-Gross, your attorney, wants to have you evaluated. So she'll contact you. I'm gonna put you back in a breakout room for a few minutes. And when she logs back in, we'll get her in a room with you, okay?
Yes.
All
Does
right.
that mean she believed that I did this?
I can't, I'm not trying to be rude. Miss Henderson-Gross, you have a constitutional right to remain silent. Talk to your lawyer. She should log right back on, and as soon as I get her on, I'll put her in with you, and you can ask her these questions, okay? And she'll be visiting you at the jail as well.
Okay.
All right, thank you. And Miss Johnson, we don't have your number. Before you leave, can you go to the chat function and just type in your number we would contact you at if needed?
Not a problem, Judge. I do have 2 more on your docket today, so I'll be here for a little bit.
Okay, great. All right, good, sounds good. And we're gonna set a control date, 60 days out. We'll send out notice of that day. All right, thank you. And Miss Henderson-Gross, I'm gonna put you back in a breakout room for your lawyer, okay?
Yes. Thank you.
Are you recording? Okay. All right, I have most everyone on Miss Coleman. Let me get that file. Coleman? Courtney Coleman. Counsel, what's that? Oh, I'm sorry. All right, Mr. Coleman, give me 1 second. Stop looking. Have it. All right, this is hold on, 251036SM and 250210, the state of Michigan versus Courtney Coleman.
Your Honor, Nora Ali on behalf of the people.
Your Honor, Kevin Battersby, Whitnoff, PA 5532 on behalf of Mr. Coleman.
All right, so it's a time and date set for our probable cause conference on the, hold on. Oh, and we have this bond motion. We're going to address that as well now that I have all parties present. So on the misdemeanor case, the 251036, I suppose we're just going to have that follow the felony, correct?
Yes, please.
And then on the felony case, what's the status of discovery?
Your Honor, I shared paper discovery, and I just shared digitals today. So it's in the process.
Judge, I'll acknowledge that I received the digital link and that it's downloading right now. If anything is missing, I will contact Madam Prosecutor.
All right, so defendant was previously arraigned, failed to appear at his probable cause conference, and it resulted in a warrant revocation. So we have these 2 cases in front of me. On the domestic violence, he had a $5,000 cash bond right now. And defense counsel did file a motion. He came in on a date last week. But it wasn't a state date, so I didn't have the proper prosecutor ready to address bond. What do the parties want to tell me about bond?
Your Honor, I don't believe that we were able to come to an agreement, so I'd be happy to argue my motion. This court would be
Okay.
willing.
Your Honor, I'm going to object to any type of modification to the bond. If you would, I don't know who you wanted to hear first.
Well, no, I'll hear his motion and then you can respond. Go ahead, counsel.
I'm not going to belabor this point because this will be the 3rd time that I've made my points in front of Your Honor. I have no doubt that Your Honor reviewed my bond motion. I'm sure Your Honor remembers. Last week, I believe it was Wednesday, when I made several points about why Mr. Coleman should be released. But I will bring one additional thing to Your Honor's attention, and that's Michigan Court Rule 6.106, which explicitly outlines when the court may deny pretrial release to an individual. Now, of course, Your Honor, this rule does pertain to arraignments, and I understand that Mr. Coleman was previously arraigned. However, I believe that the policy is still sound. And the policy explicitly written here is that the defendant, in order for the court to deny pretrial release, must be charged with murder, treason, must be charged with criminal sexual conduct in the 1st degree, armed robbery, kidnapping, or must be charged with a violent felony and must have had a violent felony in his past. And while we recognize that these allegations which is all that they are, Your Honor, amount to a violent felony and the assault with intent to do great bodily harm less than murder. To the best of my understanding, Mr. Coleman has nothing in his criminal history that would rise to the level of a violent felony. And as a result, to remand Mr. Coleman would go against the sound policy written into that court rule. I'm asking Your Honor to please release Mr. Coleman with a tether, because I believe that the tether will accomplish the two goals that this court has to consider when evaluating bond: community safety and likelihood of having Mr. Coleman return to court. Obviously, Your Honor well knows why the tether would keep Mr. Coleman from absconding. The moment that he does, he would be picked up immediately. But again, I will remind the court, as I spoke about last week, that in terms of community safety, I have no doubt that the court's concern is keeping this individual, the complaining witness, safe, and an exclusionary zone on her home, work, any area frequently visits would ensure that Mr. Coleman has absolutely no contact with her, keeps her safe, and again, ensures that Coleman returns to court. I do believe the court can accomplish its goals by releasing Mr. Coleman on a tether, and that's exactly what I'm asking the court to do. Thank you.
All right, so I want to be clear, because I looked at this file, Mr. Wittenoff, after you were here last, because the bond did not make sense to me, and it's because he failed to, the reason it was set at no bond was simply our system does that when someone fails to appear, and then bond has to be reset. So the only reason he was on that bond was because of his failure to appear at the PCC. Counsel, I don't need your response. I'm familiar with these files. And quite frankly, I just do not believe that a personal bond is appropriate, or even a low cash bond. The allegations in this case are alarming, and I have significant concerns for the complaining witness. There was a domestic violence that was alleged to have occurred on January 28th through 2025. It's my understanding that the parties separated in between that date and the next date, and the allegation is he was not residing in the house, and that the complaining witness woke up and had a feeling, if you will, that someone was in the home. And the allegation is she tried to call 911, and the allegation, the defendant snuck into her home and was lying on the floor next to her bed, and then got up and started strangling her and telling her he was going to kill her. They're allegations, but they're frightening allegations, and I don't see how a personal bond is appropriate under those facts.
Your Honor.
Yes.
If I may, in regards to the tether.
Yeah.
Because I know that he was asking for a tether. I did speak to the complainant on Zoom before this hearing. She advised that on the date that this allegation occurred with the strangulation.
Can you talk louder? I want to make sure
On the day that this strangulation occurred, she had advised that he was actually on tether for a previous case that was already open. And again, I would object to any type of bond modification. It seems that he doesn't really follow court orders, especially given that this is the first time we're here after he did not appear the last couple of times.
Your Honor, if I may just briefly respond.
Go ahead.
Your Honor, I appreciate the prosecution's point, I do, but I question whether or not the tether that she just referenced had a specific exclusionary zone for this individual's locations. And Your Honor, I understand that the court is disinclined to give a personal bond. We would ask that this court give a monetary bond with a 10% provision that Mr. Coleman can afford to give this court, so he may show this court that he wants to comply with its orders. He is very, very serious about fighting these allegations and wants to come back to court, Your Honor.
All right. What kind of bond was he on? What was the tether for?
It looks like, I believe organized retail crime, that there was a case opened on March 25th, 2025. I believe that was the case he was on tether for. But regardless, even if her location was not restricted to tether, and he still committed a crime along that tether, and I think that's enough to show that he doesn't commit to following a court order.
Yeah, I'm just incredibly concerned for the complaining witness. These are allegations, but until I hear testimony, I'm just not inclined to give low cash bonds with or without a tether. On the domestic violence case, he has a $5,000 cash or surety tether with a GPS tether, and we'll set that pretrial for 8/18. And then on the felony, he has a $100,000 cash or surety bond with the GPS tether. And at the exam council, if you want to, once I hear testimony, if you want to readdress bond, I'll do so. The exam will be August 18th at person at 11 a.m.
Thank you, Judge.
All right, we're all set. And we'll see everyone back at that date. Is discovery complete?
As of right now, yes, but it is still ongoing.
Okay.
Whatever comes up, I will send out.
All
Yeah,
right,
so-
we're all set. I'll see.
I'm sorry, if I could just make one note of discovery. I did receive a link to digital on the felony. Miss Alui told me that she does not have digital on the MIST right now. If it exists, I'm obviously demanding it, but I have no doubt that she will get it to me whenever it becomes available to her.
That's correct. For the computer, it's still.
All right. We're all
Thank you.
set then. We'll see everyone back. Thank you. All right, this is 250168FY, the state of Michigan versus Carlton McLean. Mr. Riggins?
Morning, Your Honor. Good morning to your staff. Neighborhood Services by Riggins, P82125, on behalf of Carlton McLean.
All right, so the forensic center did come back to finding of incompetence. I probably need Ms. So back in here to see if she stipulates. Can I get your appearance on Mr. McLean?
Donna Silva on behalf of the people, P 7439.
All right, and Mr. Riggins, I have your appearance on record. So we've already actually come in on this and referred Mr. McLean for competency. There was a stipulation previously to the finding of incompetency, and now we're back essentially on a control date here. And I have a report dated July 18th of 2025.
Yes, Your Honor, I have the same report. In addition, Your Honor, Mr. McLean had another matter that was before the Honorable Nicholas Hathaway, where he was also referred for competency, and I believe he was also found incompetent on that report. So we will stipulate to the report My only issue with the report, they cite his ongoing mental condition and his low IQ. I'm not sure if either one of those things is restorable to the point that we will ever be able to find him competent if that's what they're finding him incompetent on.
Yeah, I don't, I mean, that's not my judgment call to make yet, but I certainly recognize that's what the report says. Ms. So do you have a position on this?
Your Honor, I would stipulate to the findings. I think I would leave it to the experts. If at some point they find that he's just beyond being restored or he's not, then we'll take the appropriate measures then. But for now, I think we just have to go through the process.
Is he out of custody?
Mr. McLean is in the center, is in Walter Reuther Forensic Hospital. He's been there since May 27th.
All right. The recommendation is that he continues to receive ongoing psychiatric treatment in an outpatient setting. So, Mr. Riggins, does that seem appropriate to you?
It would seem appropriate. I can, I will check with my social worker to see if there is an appropriate outpatient facility that she can recommend for the court. At this point, I don't know any. That admittedly, this is not my area of expertise, but I will certainly check.
All right. Well, I mean, he could go anywhere for outpatient. He could go to the guidance center. He's probably previously received some mental health treatment at another facility. Miss McLean, Melissa McLean. Miss McLean, can you unmute?
Hello, I'm sorry.
Hi, Miss McLean. If Mr. McLean was released from custody, would he go back to your residence?
Yes.
All right. And is that what you desire?
Yes.
Okay, I'm gonna get a Mendes bond to a $5,000 personal bond. And Ms. McLean, I don't want to get in too much to Mr. McLean's medical history, but I'm familiar with this case to some degree. Has he previously received outpatient care at a facility?
Yes, he goes to Pure Psychiatry.
He goes to where?
Pure Psychiatry of Wayne, Michigan.
All righty, so to comply with, his doctors and work with his doctors on that. And, so on the order for competency, I'm checking box 2. It says the defendant's incompetent to stand trial, but may be restorable. There's a substantial probability that the defendant, if provided a course of treatment, will obtain competence to stand trial within the time limit. And I don't have information one way or another, but we're certainly well within the time frame allowable by statute. It goes on to say you'd be committed to inpatient unless the forensic center deems it unnecessary, which they have. And if inpatient commitment is not necessary and the defendant is not incarcerated, which he will not be because I'm giving him a personal bond, The Community Mental Health Services Program where the defendant resides is appointed as medical supervisor of treatment, and MD HHS shall notify the court in a different medical supervisor if a different medical supervisor should be appointed. So I'm checking that box because that's the only option I have. But I'm assuming, Mr. Riggins, they'll be in contact with you.
Yes.
And Mr. McLean's just to comply with his treatment orders, but it looks like he'll be assessed likely one more time, or at least reviewed by forensic center and then released to outpatient. And I think we're all set. Hi, ma'am.
Hi, my name is Ashley Kelly. I am court liaison. Do you think once that finding an order on competency is completed, you can send that over to Walter Ruther?
Yes, and I'm assuming he'll be assessed there before being discharged to an outpatient treatment facility.
Yes, let me get to where you can see. Okay, yes. So basically, Mr. McLean, he also has a hearing on August the 7th for competency as well. And so it's going to be determined on how that hearing goes if he's discharged.
Okay. Ma'am, do you see the chat function on your device?
No, I do not.
Okay,
but I can locate it.
Hold on. Yeah, because I need your contact information, but we live stream and I don't want you to give me your email and phone number and all your information where it's, you know, on the internet. If you look
what I can do once this is over, I can contact your court and provide my information.
Perfect. Just call my criminal clerk and let her know what you're here on, and we'll get all that over to Walter Ruther for you.
Okay, thank you.
All right,
and
thank you.
If I may, regarding the hearing on August 7th, that hearing is before the Honorable Nicholas Hathaway for a case prior to mine. I believe Jane Wyrick is the attorney on it. I do know that case is essentially timed out. So one way or the other, that case, it has the same finding that he is incompetent, and I think he is has a date of it's mid-August. So that case is essentially timed out.
Okay. All right. Well, then he'll be all set, and I'm giving him the personal bond. The only reason Mr. McLean was put in custody on this is because he wasn't showing up for his interviews. So now he's being assessed.
And I have a question. So if that August 7th case is timed out, does he still need to report for that hearing, or what is going to be the conclusion?
So the August 7th is still within the time frame. I do know from seeing the report that he will time out mid-August. I want to say the date is, I don't have that report in front of me, but I want to say the date is something like August 16th that he times out on that case.
Okay, thank you.
Okay.
All right. We're going to put you in a breakout room real quick. 1 second. All right. Over with Mr. McLean. I'm sorry, ma'am. I didn't write your name down. Are you in the room still?
Yes, my name is
Ashley. Okay, Ashley.
Kelly.
All right, Miss Kelly, I'm going to put you in a breakout room real quick with our checking clerk. She'll take your address and your phone number and your contact info right now.
Okay, thank you.
All right, thank you. Mr. Gazicki, do you have something ready?
Yes, Your Honor, I have Cagle, that's in Wayne County.
All right, are you Miss Cagle's mother?
Yes, I am.
Okay, her mother's present. This is 2514443, 2511797, 252181, the people versus Sarah Cagle.
Morning, Your Honor. James Gazicki on behalf of Sarah Cagle. Your Honor, we're requesting a settlement conference where the victim will have to appear. Also, I'd like to address bond.
Okay. We'll set a settlement conference on all of these. They all have the same complaining witness. So, we'll do that. And Mr. Gazicki has to bond.
Mr. Bond, Your Honor, I'd ask that right now it's set, I think, at $1,000 and there's two $100 bonds. I would ask the court for a personal bond with a GPS tether. Prosecutor indicated that she's comfortable leaving it to the discretion of the court as long as a GPS tether is there and there's no contact with the victim or the address on Ziegler.
All right, and Ms. Cagle's mother's here. Ma'am, can you come up to the podium real quick? And tell me your first and last name.
Peggy Cagle.
What is it?
Peggy Cagle.
Okay, so Ms. Cagle, if your daughter was released, would she be with you?
I would want her to come back home. I don't believe she needs a tether because she needs to be home. She got no place else to go. I want her home so I can help her.
Okay, does this complainant live with you though?
A part-time.
Okay, well, he can't be there.
Okay.
Victor Villapando.
Right.
Here's the problem, because Ms. Cagle, I am aware, I am familiar with Ms. Cagle. I understand that she has some underlying conditions, but every time I let Ms. Cagle out, she picks up another case with the same defendant or with the same victim. She can't go near him.
Okay.
And he can't go near her.
Okay.
So if she's going home to your house and
Yes.
I'm amending the bond, he can't be allowed at your house.
Okay.
Because
I
if so,
understand.
she's gonna have 4 cases.
I understand. I appreciate that.
So ma'am, you'll have all, Ms. Cagle, I'll convert all your bonds to personal.
Thank you. Thank you.
And then but I am going to give her a GPS tether.
Does she have to have one of those?
Here's the thing. She's got 3 assaultive cases
I
against
understand.
the same victim, and they just keep happening. And then she goes into warrant status until she's picked up. She's got one on 5/10 of 25, one on 6/21 of 25, and then one on 7/23 of 25. So every 30 days, she picks up a new DV case with the same victim. She can't go to where he is at all.
You're muted, Your Honor. We didn't hear what you said.
Can't hear you, Your Honor.
I'm sorry, what?
Okay.
We can't hear you, Your Honor. We can hear the mom, but not you, Your Honor.
Can you hear me now?
Yes. Yes, Your Honor.
Yes, Your Honor.
Okay, I'm sorry. All right, so Miss Cagle, you understand you cannot go near Victor Villapando.
Yes, I understand that.
All right? Because
I'm
if you go
aware,
near
yes.
him, you're gonna end up back in jail.
I am totally aware. I meant no harm to that man, and I do not plan
All
to
right,
be
don't
around
tell
this
me
man.
about it. I'm telling you. All
I
right.
understand, Your Honor. And I'm okay with the GPS tether just so I can get back and forth to work and home.
All right, she's got I'm giving her a GPS tether to ensure compliance and to make sure she comes to court because she keeps missing court.
Okay, thank you.
Yes, Your
Yep.
Honor.
And all your other conditions will still apply. Most importantly, you stay away from him, okay?
Yes, Your Honor. Thank you.
All right, we're all set. Thank you. And we'll set them for a settlement conference with everyone to come to court and appear.
Thank you.
All
Your
right,
Honor.
thank you. All right. Oh, wait, I need those. No, I don't. All right. Schillingburg, this is A2TA 2522438, the state of Michigan versus David James Lowry. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name for the record?
Corporal Billy Schillingburg.
Have you read the type complaint that was filed with the court?
I did.
Can you state the facts that support the issuance of the arrest warrant?
On August 1st, 2025, at approximately 12:11 a.m. Sorry. 12:11 a.m., Officer Crawford and Officer Nagy observed a 2024 Transit U-Haul with Arizona license plate AM 68845 traveling westbound on E-course approaching Morgantown at a high rate of speed. The U-Haul was occupied by two white males. The driver, later identified as arrestee David Lowry, date of birth July 3rd, 1984, and arrestee Justin Spears. Officer Crawford and Officer Nagy were working as a two-man unit operating fully marked Patrol Vehicle 210. Patrol Vehicle 210 has the words police displayed on both sides of the vehicle and has flashing blue and white lights. As Officer Crawford and Officer Nagy pulled onto westbound E-course, the U-Haul quickly turned southbound on Cagle without using a turn signal. Officer Crawford then turned southbound onto officers observed the U-Haul begin to increase its speed down Cagle. The U-Haul then struck the listed 2008 Ford Fusion. Officer Crawford then acted with their overhead emergency equipment, the lights and sirens to initiate a traffic stop. The U-Haul then began to rapidly accelerate. Officer Nagy then advised dispatch of the situation and advised that the officers initiated a pursuit on the U-Haul, and the U-Haul was traveling approximately 6 miles per hour in a posted 25-mile-per-hour zone on Cagle. Officer Nagy observed the U-Haul disregard the posted stop sign at the intersection of southbound Cagle and Champaign. The U-Haul then began traveling westbound on Wolffowl. The U-Haul then disregarded the posted stop sign at the corner of Clipper and Wolffowl and began traveling southbound on Clipper. Officer Nagy then observed the U-Haul travel southbound on Clipper until it reached Wick Road. It should be noted that Clipper is also a 25-mile-per-hour speed zone with speed signs posted on northbound and southbound of the street. The U-Haul then began traveling westbound on Wick from Clipper. Officer Nagy continued to call its speeds and direction of the travel during the pursuit, and Officer Crawford turned onto westbound Wick. Officers lost sight of the U-Haul. Officer Nagy then observed the U-Haul on northbound Dudley in front of 9041 Dudley. The U-Haul struck the listed 2004 Dodge Ram. The U-Haul was unoccupied with all the doors open. Officer Nagy notified dispatch that the U-Haul crashed out and the occupants fled on foot and requested additional units to make their location. All officers on shift working that day arrived on scene and immediately set up a perimeter, and dispatch advised that Southgate's K9 was en route to the location for a track. Officer Crawford spoke to Penelope Benson at 9077 Dudley, who stated she had a ring camera footage of the driver and passenger running from the U-Haul. The driver was a bald male wearing all black clothing running eastbound. The passenger was wearing a white shirt, blue shorts, and flip-flops running westbound towards Catherine Street. The K9 track began in front of 9041 Dudley in the backyard of 9077 Dudley, eastbound into the backyard of 9052 William, northbound into the front yard of 9028 William. Officer Nagy spoke to Christopher Darmetko, who resides at 9052 William, who stated he has surveillance video footage of a white male wearing all black clothing running into his backyard, jumping the fence, and running into the backyard of 9028 William. Officer Nagy observed this male to be the same male that was driving the U-Haul, also known as David Lowry. Dispatch advised that David Lowry is registered to 9028 William and has multiple felony and misdemeanor warrants from surrounding jurisdictions. Should be noted that this is the same address where Officer Wing was also assaulted by a white male that fled from the location on foot. Officers on scene set up a perimeter around 9028 William and began to hail everybody out of the house. After several minutes, Lowry presented himself from the home. Lowry was immediately placed into handcuffs, searched, and secured on Patrol Vehicle 213, and he was advised he was placed under arrest.
And did you sign the complaint before you sent it over to the court?
I did.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense and I'll therefore issue the warrant.
Thank you.
Thank you. Zach, I just need one real quick second.
Leave that here until they might come in with a plea.
Okay.
Brittany Johnson on behalf of the people, P83513.
Is this on Al-Ghazali?
Yes, Judge.
All right, I'm looking to see if he's here.
He's with his
He's
attorney.
with you?
He's with me, Your Honor, yes.
Okay, this is 252-188-FY. I've got Madam Prosecutor's appearance. Counsel, can I get your appearance?
Good morning, Your Honor, to you and your staff. Jamil Moran, P84246, on behalf of Ayman Al-Ghazali.
All right, Madam Prosecutor, or I'm sorry, Madam Interpreter, can you raise your right hand? Do you solemnly swear or affirm to accurately and completely translate from English to Arabic and Arabic to English?
Yes, I do, Your Honor.
Okay, and can the defendant tell me his first and last name?
رجاء قل اسمك.
أيمن علي الغزالي.
أيمن الغزالي.
Yeah.
All right, it's the time and date set for the probable cause conference.
اليوم راح يكون اليوم والوقت للمحادثة هاي.
Okay.
Okay.
What is the status of discovery?
Your Honor, we're actually looking for some additional discovery. We're looking to adjourn this maybe 3 to 4 weeks at the court's discretion in order for us to have another probable cause conference.
Judge, I did send that over about in the last 5 minutes, so I don't believe they've had a chance to review it, but they should have everything in their possession now.
All right, hold on.
مستر الغزالي قاعد يسأل إنه إذا في إنه يأجلها أسبوعين 3 ويتقابلون مرة ثانية بعد فترة من الوقت.
Okay. Yes.
All right, I am not inclined to adjourn a PCC out 3 to 4 weeks. He was arraigned on July 28th. It's August 4th. I understand there might be a discovery, and I'm assuming there may be some other ancillary issues that need to be looked into or addressed. But I can set an exam for 2 to 3 weeks out, but I'm not inclined to set another PCC. I can do I mean, we have to have this exam within the next 2 to 3 weeks.
Your Honor, I have explained the 21-day rule to Mr. Al-Ghazali. If we can adjourn the PCC maybe 2 weeks and then handle it that way if the court may.
All right, well, we're gonna have to, I mean, if I set the exam out 2 weeks, we're doing the exam in 3 weeks. I'm doing this exam within 3 weeks. Like there is not, we're already over the time frame or will be. But the latest I'll go on the exam is the 25th. of August. So we can do a PCC, an adjourned PCC on August 18th, but the exam's going to proceed on August 25th.
Okay, those times are fine.
Those dates are good for the people, Judge.
Madam Interpreter, do you need to interpret that?
توم راح يتقابلون مرة ثانية. المقابلة الثانية والحكم حيكون إن بالشهر الثامن 25 بالشهر.
Okay.
So our
Okay.
adjourned PCC will be August 18th at 9:15 a.m.
So راح تتقابلون بشهر الثامن و15 بالشهر أولاً، والموعد الثاني راح يكون بشهر الثامن 25 بالشهر. So 15 و25.
And the exam will be August 25th
والامتحان فور هالشي حيكون بيوم الشهر الثامن 25.
at let me see. At 11 a.m.
الساعة 11 الصبح.
And that'll be in person at the 23rd District Court, that exam date.
وراح يكون المقابلة شخصياً، لازم تأتون للمحكمة.
And counsel, can you voir dire your client on the waiver of the 21-day rule?
I have, Your Honor. He understands those rights and he's waiving those rights.
محاميك قال إنه تعرف أنت حقوقك وتعرف شنو المطلوب منك.
Yes.
Okay, can I see him?
Yes.
تريد تشوفك؟
Sir, you understand you have a right to a preliminary examination within 21 days of your arraignment?
تعرف إن عندك حقوق إنه تسألها وتعرفها قبل المقابلة الثانية، صح؟
Yes.
Yes.
And your client's asking, or I'm sorry, your attorney's asking for time outside of that 21 days so he can prepare for your exam.
والمحامي تبعك دا يسأل وقت أطول خارج المدة المحددة اللي هو 21 يوم على مود يجيب إثباتات وحقائق دا يستعملها بقضيتك.
Are you waiving your right to have that hearing within 21 days?
So أنت تسمح لهم إنه يغيرون الموعد أكثر من 21 يوم؟
Yes.
Yes, Your Honor.
All right, I'll accept the waivers, no one involuntarily given. See everyone back August 18th at 9:15. Bond continues.
So تتقابلون مرة ثانية الشهر الثامن و15 بالشهر ونكمل من هناك من هذا الموعد.
Thank you.
Thank you, Your Honor. Thank you, Mr.
All right,
Deville.
and thank you. And then I have Ms. Kraus. Are you ready on Miller?
I am, Judge.
All right, this is 252189, the People versus Michael Miller. Can I get your, I don't have the prosecutor in here. Hold on.
That's me again, Judge.
May I leave? I'm sorry.
I do. Yay. Can I get appearances?
Brittany Johnson on behalf of the people, P83513.
And Sarah Kraus, P81830. I'm standing in for the attorney of record, Godby Silver, for Michael Miller, who's present on screen from the adult detention facility. Mr. Miller, can you unmute, please, and state your name?
Michael Miller.
All right, as to the probable cause conference, Ms. Kraus, what's the status of discovery?
Judge, I believe Ms. Johnson just sent over discovery this morning. We have not had a chance to review it or go over it with our client. I am asking simply for a week adjournment of the probable cause conference so we can meet with him.
Okay, and I requested a DSU on your client at the time of his arraignment. Excuse me. So it's been a week and I don't have it back yet. But we'll adjourn the PCC 1 week to August 11th at 9:15. Ms. Kraus, can we set the exam date now?
Judge, I would prefer to wait until next week. Miss Silver may or may not be leaving town. I'm in a jury trial consecutively every Monday after the 11th, so I don't know if she will be here to handle it. So I would prefer to do that next week if we could.
Okay, do the two councils, Ms. Johnson, do you two want to discuss bond today, or we'll just address it? I mean, I want you two to talk about it and see if there's some sort of agreement between the parties. I know on some of the other matters with the identical charges, there have been bonds stipulated to by prosecutor and defense counsel. So you two want a room?
Yes, please, because I would like to address Mr. Miller's bond today.
All right, then you two go talk and I'll see you back in a few minutes. All right, Miss Segura, what do you have?
I have, yeah, Robert Taylor and Stephanie Harris. Robert Taylor is in a breakout room. He's not in the custody of the jail.
All right, let me get him in. And you two should get a breakout room to join. All right. This is, and I have a form, but it doesn't say anything on it.
Yeah.
All right, this is 252172, the state of Michigan versus Robert Taylor.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Robert Taylor, who is present via Zoom from the Wayne County Jail. Mr. Taylor, will you please state your name for the record?
Robert Douglas Taylor.
All right, and it looks like he's here today for a probable cause conference. Ms. Segura?
Yes, Judge. So I have received paper discovery in this matter. I have yet to receive digital discovery, but Ms. Sove indicated that she would send that to me. So I'm just waiting for it to be uploaded. I am prepared to schedule the preliminary examination, but in speaking with Mr. Taylor, I first wanted to address bond, and then depending on what happens with his bond is kind of how he wants to proceed with this matter. So he is being charged with uttering and publishing. He is a habitual fourth. However, I would note for the court that his last charge, or I guess interaction with the criminal justice system, was back in 2017. Doesn't appear that he has a violent history. It looks like just some theft-related offenses, Judge. And what I can say is that Mr. Taylor, you know, obviously understands that, but he has been getting on a better path since getting out in 2017. He is living in a homeless shelter. I can provide that shelter information to the court. He also has constant contact with his mom and sister. He has a phone number that he can be reached at the shelter. His fear is that just the longer he stays in custody, the harder it's going to be for him to return to the shelter and have a bed available for him. And so that's kind of our hope, is to get him a personal bond. And then if so, we can proceed with scheduling the examination on the 18th. I don't believe that he is a flight risk. I do not believe that he is a danger to the community. It is an uttering and publishing, non-violent, not assaultive, no weapons involved. And it doesn't believe or appear that the check that was alleged to have been possessed was even cashed. So I do believe that a personal bond is appropriate in this matter, Judge.
The reason he wasn't given a personal bond the last time he was here was because of his failure to appear at courts. I agree that in Michigan, he's not really had much. I'll recognize, I don't see an assaultive history. In Michigan, it looks like he hasn't had a crime here. He got 93 days in jail in 2017. But I've got his out-of-state report, and out-of-state, he's got warrants out of Kentucky. None of them are, you know, extraditable extraditable, is that a word?
Possibly.
They're not extraditing him on any of them, but he just has this history of not showing up to court.
Oh, I promise I will show up, Your Honor. Like I said, I just want to resolve the matter and get this taken care of and do everything I can. I'm not gonna leave the state. I'm not gonna leave the city. I'm gonna go to the homeless shelter, check back in, get in my bed, and find a job and report to the court dates I need to report to.
It's a non-violent offense, no history of violent offenses. I'm going to convert his $5,000 cash bond to a $5,000 personal.
Thank you, Judge.
Thank you, Your Honor.
Show up to court or I'll
I know, I will show up.
put you back in.
I know, I understand, Your
All
Honor.
right. And then
Thank
we
you so
have
much.
dates on Mr. Taylor. Hold on.
Thank
We
you.
set our dates on him.
So then, Judge, we'd be willing to set it on the 18th, if that works for the court.
August 18th, huh?
What time, Judge?
We have quite a few that day. Let's see. You're here all day. Let's do 1 o'clock.
I will be,
Date 18 at 1 p.m. in person at the 23rd District Court.
and then Taylor,
Yeah, 23rd District Court. And you have a way to contact your client?
Yes, I provided him with my card.
All right.
Call me when you get out, Mr. Taylor, okay?
yes, I will.
All right, thank you.
Am I all set then?
You're all
Yep, you're all
set.
Thank you, Your Honor. Thank you.
This is Michael Miller. It's right here. I have it. All right, I see that I have Miss Johnson and Miss Kraus back out on Michael Miller. Did the two of you discuss bond?
Yes, Judge.
Yes, Judge.
And
We are going to agree to a personal bond with a GPS tether.
That's correct, Judge.
all right, it's 150 and stipulation of the parties. There will be a bond modification of $150,000 personal with the GPS tether. These bond conditions will still apply. All of his bond conditions, let's see. He's to appear in court as directed. He's not to leave the state without permission of the court. He's not to commit any new crimes while released. He's to immediately notify the court of change of address or phone number. Cannot possess or have access to firearms or other dangerous weapons, cannot consume alcohol or illegal drugs, may be subject to testing on demand, must have a GPS tether, cannot have any contact, have unsupervised contact with minor children, with minors, period, and he cannot access or use the internet. Understood?
Yes, ma'am.
All right, anything else?
Not
Not from defense. Thank you, Judge.
All right, we're all set. Thank you.
Thank you. Have a good day.
Yep.
Morning, Judge.
Morning. I have Stephanie Harris up here. Is that you? Yep. All right, I've got Ms. Harris. All right, this is 252191FY, the state of Michigan versus Stephanie Harris.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Stephanie Harris, who is present via Zoom from the Lane County Jail. Ms. Harris, will you please state your name for the record?
Stephanie Harris.
And Judge, today is a date and time set for a probable cause conference. I did receive paper discovery in this matter. I have yet to receive digital discovery, but Madam Prosecutor did indicate that she would send that to me via email today. So I am prepared to set the preliminary examination. Considering Ms. Harris is in custody, if the court could accommodate next week on the 11th, that would be greatly appreciated. But I understand if the court can't accommodate that.
One, two, three. 2, 3. 2, 3, 4. It'll be interesting. We can set it at 10 a.m. and see what happens.
Okay, that works for me, Judge. And then if I could address bond whenever the court is ready.
Okay, go ahead.
So Judge, Ms. Harris is being charged with aggravated stalking and malicious destruction of a building, 200 or more, but less than 1,000. I don't believe that there's a habitual offender notice attached. What I can say about the situation is it's unfortunate, considering there was just from my understanding, a PPO had been issued against her at her own home that she shared with the complainants. I do believe that they both had this home together, both their names are on the home. Because he filed a PPO, she was kicked out. So this led to a lot of misunderstandings, I believe. That was why she was arrested, because she was at the home. And I won't get into the specifics. Obviously, there is some charges of malicious destruction of property. But if it's her property, then that might be an issue, come exam judge. But what I'm saying for this purposes is that this isn't someone that is just going out there being violent and aggressive towards anyone near her. Understanding that there is a PPO against her and this address, she would agree to a GPS tether so that we can ensure contact order is complied with. She does have a friend that she can stay with. I believe she's able to provide an address for that location. And I don't believe that she is a flight risk. She's been a long-term resident of Taylor, and she has community ties here as well. So I do believe that this is someone that we can assure she will come to court.
Her bond is currently $45,000, 10% with the GPS tether. My understanding or the allegations are that she was served a PPO and went to the one place she wasn't allowed to go and is alleged to have broken the window at someone's residence. And I understand she may or may not have an ownership interest in that property. But Ms. Segura, when you've got a PPO, you go to court and you fight the PPO. You don't go to the house with a crowbar, right? And it's concerning to me. Mr. Holmes, have you had any contact with Ms. Harris since this date of this incident?
No, I haven't, but she did try to reach out and contact me after being served the PPO. So I got.
Okay, since she's been in jail on this case, she's not trying to call you from jail?
No. Yeah, so I don't want to press charges for the aggravated stalking or for the damages. I just want Miss Harris just to stay away, and so I can sell this home, and so we can both go our separate ways.
All right, well, here's what, you are gonna have to talk to the prosecutor about that, because that's not, I mean, I don't make determinations like that, Mr. Holmes, the prosecutor does. Is that
Yes, Your
your
Honor.
case, Ms. Cole?
I don't believe it is, Your Honor.
Okay.
Are they in their
All right, is this Miss Louis?
Yeah, it should be. It's an intimate.
All right, we'll put you in a room to talk to Miss Louis, but given what I've just been told on the record, I'll convert it to a $45,000 personal bond, but she is getting a GPS tether.
Understood, Judge.
So ma'am, your bond's converted to personal, you do have a GPS tether. You cannot go anywhere near that home or Mr. Holmes. Do you understand me?
Yes, ma'am.
Okay. All right, we're all set, and we'll set it for an exam August 11th at 10 a.m. And Mr. Holmes, we're going to put you back in a room so that you can talk to Miss Louis, your prosecutor, okay?
Okay, thank you.
Thank you. And
You're all
we're all
set, Ms. Harris.
set.
I'll come see you, okay?
All right, do I have anyone up? Mr. Colobus, are we holding on your case?
No, Your Honor, if I may.
Yeah, well, give me a sec, because I don't want you to tell me twice. Kyle, is your client with you?
That's what I was gonna say. My clients always showed up for my office visits timely and court visits timely. Today he's not here. When I checked my letter that I sent out from the office, we told him to be here at 10:30 rather than 10. It's about 10:45 currently.
We'll give him till 11.
Okay, that
We'll
sounds
see,
good.
we'll call it at 11.
I guess ultimately, if he's not here, then I would ask for a 1-week adjournment. I don't think there's any objection. It's not a, well, anyway. Thank you.
Okay. All right, we'll give him 10 minutes.
Excuse me.
All right, we're on a 10-minute break.
August, I'm just gonna ask that you make sure you send that over this morning, the judgment, and the amount to be paid to save is 2568, 87 or 82, I can't read my own writing.
87, Your Honor.
87. Okay. Gibraltar Point versus David Adams, 2502978. Is Mr. Adams here? I don't see him out there. He paid for
Your
a
Honor,
sec.
that's a 10:30, so
Is this one at 10:30 too?
it is. So we just got to give it a couple more minutes.
The only other, the 10 o'clock, Your Honor, is Water's Edge versus Erica Whiting, and she is present. We have a consent if we could call that one.
All right, well, Bailey was scheduled for 10.
Correct.
Yes, correct.
All right. All right, I don't know where I'm going now with these. Which one did Mr. Mudar have? Is he back yet or not? Tell me which ones I should call next, you guys.
Your Honor, Water's Edge.
Water's Edge versus Erica Whiting, 2502726. Is Ms. Whiting here?
Yes. She is.
Ms. Whiting, your name, ma'am?
Erica Whiting.
Do we have Ms. Ellison, your name?
Attorney Elizabeth Ellison, P 82098 for the plaintiff.
Do we have proof that she made application for funding?
She got denied, Your Honor, so we got a consent judgment.
Okay, go ahead.
Your Honor, rent to retain is $2,480, $100 in late fees at $25 a month for 4 months. That's $100. Cost of $184.17. The total is $2,764.17 for an extended writ date of August the 19th of 2025. No money judgment. I did explain her rights under MCR 4.201J. She did give me permission to sign and submit to the court, Your Honor.
Ma'am, do you agree that you owe that amount, 276,417?
Yes.
And do you understand that you have to pay that amount? Is it still the writ date of the 14th?
The 19th, Your Honor, works.
19th. Do you understand you have to pay that amount or vacate by August 19th? If you fail to do either one of those things, then you're going to be evicted. Do you understand that?
Understood.
Does Ms. Ellison have your name, your permission to sign your name to this proposed consent judgment?
Yes.
And you understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
All right, so I'll enter a judgment as soon as I receive it, 276,417. You have to make sure you pay that amount on or before the 19th, okay?
Yes.
Any questions, ma'am?
No.
Good luck. So now I got another water's edge that's set for 11. So now where am I going? Preston Point?
DCC Properties, if you have that one, Judge. Or Preston Point, either one. They're
Preston
both ready.
Point versus, I'm sorry if I mispronounced this, Tricia Stevenson, 2502753. Is Tricia, there you are. Your name, ma'am?
Tricia Stevenson.
You got to keep your voice up nice and loud. Make sure you have that centered. State your name again.
Tricia Stevenson.
You got to turn up the volume, speak more directly into it.
Can you hear me now?
Not very well. I mean, I can hear you, but nice and loud for me.
Okay, can you hear me better now?
A lot better. Thank you. Your name?
Tricia Stevenson.
Mr. Newman, your name?
Good morning, Your Honor. Philip Newman, appearing on behalf of the plaintiff.
Did you apply for funding, ma'am?
I did apply for funding, and I had got a letter for an interview for tomorrow.
Did she provide proof of application for funding, Jennifer?
Judge,
I did provide the application when I did the paperwork at the courthouse because I only had it in screenshots.
Wait a minute.
Yeah,
Jen?
she did the form, Judge, here at the court. Yep.
Okay. And you have an interview tomorrow about the status of the funding?
Yes.
All right.
Your Honor, the submission that the defendant made did not attach anything to it. She simply said that she had applied for it. I'll leave it to the court's discretion how the court wishes to handle this.
I'm going to go ahead and adjourn it for 2 weeks. That's it, though. You either have to have the funding or I'm going to give them a judgment. Okay, ma'am?
Okay.
What are we doing, Jen?
2 weeks would be the 18th.
At?
We can do 10 o'clock.
At 10 a.m., okay? So make sure you follow through on that, all right?
Okay, thank you.
Preston Point versus Anthony Weimer, 2502755. Mr. Weimer, your appearance, you have to take your hat off, sir.
Yes, sir.
Your name?
Anthony Weimer.
Mr. Newman?
Good morning again, Your Honor. Philip Newman, appearing on behalf of the plaintiff.
Did you make application for funding, Mr. Weimer?
Yes, I did, and I was denied.
Okay. So, Mr. Newman, why don't you give me a breakdown as to what you believe is owed?
Thank you. I would indicate to the court that Mr. Weimer is about to move out. He's going to be turning in his keys today. But with respect to the judgment amount, the rent to retain possession is $3,602. There are 3 late fees of $50 each for a total of $150. That totals $3,752. Court costs are $249.75 for a grand total of $4,001.75. Mr. Weimer has stipulated to a consent judgment, indicated that he has the statutory 10 days, but as I've indicated, he's going to be turning in his keys hopefully today. And we've agreed that he will also have a money judgment against him in the same amount. I did show him the consent judgment. He authorized me to sign his name to the consent judgment.
Is that true, Mr. Weimer?
Yes, I did.
All right, so do you agree that you owe $4,001.75?
Yes.
Do you understand that you have until August the 14th to either pay up or vacate? If you don't do either one of those things, you will be evicted. Also, there will be a money judgment entered in favor of the plaintiff against you in the amount of $4,001.75. Do you understand that?
Yeah.
You understand you have 3 business days since you're unrepresented by a lawyer to fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
Do you have any questions for me at all?
No, sir.
All right, so, and he has your permission to sign your name to that proposed consent judgment, correct?
Yes, sir.
All right, so judgment will enter, money in possession, writ date August 14th, money judgment in a like amount of $4,175, which is the amount that has to be paid to save it from the issuance of the writ. Mr. Weimer, I wish you well. Good luck. Any questions, sir?
No, sir. Thank
Do you have any more of these, Mr. Newman?
Nope, that's it for today. Thank you, Judge.
Have a good day. Thank you.
Thank you. And by the way, I hope you retire long before anything else happens.
Yeah, so do I.
Take care.
DCC Properties, is that the next one, Jen? DCC Properties versus Donald Krebs Jr., Veronica Krebs, and all occupants 2502439.
Good morning, Your Honor. Randy Lavasser, P41712, appearing on behalf of the plaintiff.
Okay, this was up for what time, Jen? 10, right? Or not?
That's a correct time.
That is 10? It was 10, Mr. Lavasser?
Yes, and defendant Veronica Krebs is present today.
Where is she? There you are. Your name, ma'am?
Veronica Krebs.
Where's Donald at?
Working. It's hard for him to get off with the job he does.
All right, so what are you doing on this one? Is there a balance still?
This is a termination of tenancy matter, but we are working on a resolution. We're asking the court to adjourn the matter for 2 weeks so that we can try to complete that, Your Honor.
Okay, we'll adjourn this until August 18th, Jen, at tell you what, I'm just going to give you at 8:30. How's that? 8:30 on August 18th, okay?
Thank you, Your Honor.
Do you have any more, Mr. Lavasser?
Nothing further, Your Honor. Thank you.
Have a good day. Thanks.
Well.
All right. Gibraltar Point is not up until, what time is that? That's at 10:30. I got to give them a couple minutes. Water's Edge. I already handled Water's Edge. We have one more of Water's Edge. Okay, Riverside Townhomes, do I have that? Versus Xavier Bellamy and Zacharias West, 2502957. All right, Mr. Mudar, your appearance. JMZ Management versus Stacy A. Moore, 2502975. Is Mr. Mudar still in the breakout room, Jennifer? Golden Management versus Patricia Lewis.
Good morning, Your Honor. Patrick Fortuna appearing on behalf of the plaintiff. My P number is P81281.
This is file 2502792. Is Patricia Lewis here? Do I see Patricia Lewis? This was scheduled for what time? Oh, I'm sorry, ma'am. Your name?
Patrice Lewis.
Did you apply for funding?
Yes, I was denied, but I took a loan out my 401k and it said 3 to 5 business days before it be in my account.
The parties have worked out a consent order conditional dismissal, Your Honor.
Go ahead. Thank you. Put the terms on, please.
With respect to the terms, Your Honor, the parties have agreed under a conditional dismissal. Rent to retain as of today is in the amount of $3,875. Court costs total in the amount of $225.43, and other money due is late fees. It totals in the amount of $125. That does comprise of $50 for June, $50 for July, and $25 for August, for a total balance of $4,225.43. Defendant has agreed to fully pay the listed sum by, on, or before August 15th of 2025, where this case shall remain dismissed without prejudice. Plaintiff has not sought a money judgment in this matter, Your Honor. With respect to 4B, I have gone over the terms and the procedure with respect to the 14-day period for objection. Defendant has agreed to waive that. And then with respect to MCR 4.201J, the 3-day business rule was also explained to Ms. Lewis in terms of being representing herself in today's matter, Your Honor. Lastly, I just kindly state for the record, I did ask for Mrs. Lewis's authorization to sign the consent order conditional dismissal on her behalf, and she did provide her consent to that as well.
Do you understand everything you said, Ms. Lewis?
Yes, I did.
So do you understand and agree that you owe $42.25.43?
Yes.
You understand this will be set forth as a conditional dismissal, which
Yes.
will have to be taken care of by August 15th. You have to pay by that date. The case will remain dismissed so long as you do so. If you don't pay by that date, it will convert to a judgment. A writ will be presented. I'll sign it. The sheriff will go out and your belongings will be removed. Do you understand that?
Yes.
You have 3 business days to come in here and fill out a motion to set aside this dismissal and those terms. And you have 10 days to appeal. Do you understand that?
Yes.
And you gave Mr. Fortuna permission to sign your name to that document, true?
Yes, I did.
All right. Do you have any questions?
No, I do not.
All right. Thanks, Mr. Fortuna. I wish everybody did that way. Have a good day. Do you have any more?
That's it, Your Honor. I appreciate that. Thank you so much.
Thank you.
And thank you, Ms. Lewis.
All right.
Thank you.
Do I have Mr. Mudar out here? Do I have any more out here?
I'm going to ask Mr. Muda to come back to the main session. It looks like he maybe got stuck in the breakout room.
Mr. Kasser, David Kasser versus Ramika Ellis. 2502952. Where is Ramika Ellis? Ma'am, your name?
Rakima Ellis.
You have to bring in Mr. Kasser.
Hello, good morning, Your Honor.
You have to start your video. Ms. Ellis, did you listen to and understand the rights in the video? Did you listen to and understand the rights in the video, Ms. Ellis, or she disappeared? I can't see her now.
Yeah, it looks like we've lost her, Your Honor.
All right, South Point Square.
Do we say Riverside versus Bellamy, Judge? Is that?
Riverside versus Bellamy and Guess. 2502957. All right, Mr. Mudar, your appearance.
Max, you have Mudar on behalf of plaintiff, Your Honor.
Mr. Guess.
Zacharias Quest.
Mr. Bellamy.
Xavier Bellamy.
All right, now. The total balance is $1,605. Do you agree with that, Mr. Guess?
Yes.
Mr. Bellamy?
Yes.
Have you limited late fees to 70 per month, Mr. Mudar?
I have limited late fees to 70 per month, and in fact, I went and removed $80 from the balance that was previously stated simply based on there being a charge on the ledger of $150 in late fees in 1 month. While it's not a month that I believe we're here for at this time, it was still addressed and updated. So now the balance that I've got is $1,520.05.
All right, give me your total breakdown then again.
Hello?
So we've got the rent to retain on this one being $1,341.05. Court costs in the amount of $179, giving us our grand total here today of $1,520.05. There is only one charge of late fees now on this ledger, and that charge is in the amount of $70, Your Honor.
All right, did you, Mr. Bellamy, you agree that's what you owe?
Yes, Your Honor.
Mr. West?
Yes, Your Honor.
All right, so you're just seeking a judgment after hearing, correct, Mr. Mudar?
So we've agreed to the terms of a consent judgment on this one. We're providing until August 15th of 2025. I would like to make note for the record, we do have language in this agreement that indicates that there was a payment, or that defendant indicates that he made a payment of $100 not yet addressed on the above balance. I don't disagree with that indication. I just don't have that on my ledger here today. I do have permission from both Mr. Bellamy and Mr. Guest to add their signatures to this resolution, and we did go over MCR 4.201J.
Is that true, Mr. Guest?
Yes.
Mr. Bellamy? Mr. Bellamy?
Yes, Your Honor.
All right.
Yes, it is true.
So you agree that you owe $1520.05. There is an indication you paid, one of you paid, or both of you paid $100. He's going to put that in further orders so that if that check clears, assuming it to be a check, the balance would be removed or lessened by $100, leaving a balance of $1420.05, which you would have to pay by August the 15th. If you don't, you will be evicted if you haven't vacated. Do you understand that and agree to that, Mr. West?
Yes.
Mr. Bellamy?
Yes.
You have 3 business days, gentlemen, to fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Mr. West?
Yes.
Bellamy?
Yes.
And does Mr. Mudar have your permission to sign your name to that document, that proposed consent judgment? Mr. West?
Yes, Your Honor.
Bellamy?
Yes, Your Honor.
All right. I wish you well, gentlemen. Did I cover everything adequately, Mr. Mudar?
I believe so, Your Honor.
Okay, so you guys are all set. Just make sure you pay up by the 15th or else you're going to have to vacate by then. Okay, thank you. Good luck.
Thank you, Your Honor.
What else do you have here that would be ready to go, Mr. Mudar?
I'm ready on all of South Point Square Apartments hearings.
I'm going to
I
take,
believe I've got one with JMZ.
right. I'm going to take, let's see here. Mr. Cassers, David Casser versus Ramika Ellis, 2502952. Is Ramika Ellis out there?
Yes, I'm here.
Your name, ma'am?
Rakima Ellis.
Mr. Casser?
Good morning, Your Honor. David Kasser.
Ma'am, did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
I've already applied.
When did you apply?
I applied 2 weeks ago now.
Have you heard from them?
I did recently hear from them, and
Your Honor.
just because I work at the hospital, they denied me. I was on medical leave.
Okay.
For my foot.
So you've been denied the funding, correct?
Yeah.
Mr. Casser, give me a breakdown as to how much is owed, please.
Your Honor, this is a termination case. There's no money involved.
I'm sorry. I'm sorry. My apologies.
Thank you.
Why don't you have to leave, ma'am?
I'm sorry.
Why don't you have to leave?
You said, why don't I have to leave?
Yes. He's not suing money. He's suing just to get you out. He has the right to do that if the lease is expired. Has the lease expired except for a month-to-month provision, Mr. Casser?
We're on a month-to-month agreement from the beginning, Your Honor.
So why don't you have to vacate, Ms. Ellis?
Well, I do have to vacate because of the rent is not paid. I haven't been able to make payments due to the fund.
He's not seeking to have you removed for non-payment of rent. He's seeking just to terminate the tenancy.
Right, and I believe that's because of the money owed. It hasn't been paid.
So, all right, what are you asking me for, Mr. Casser?
I would like to have the written 10 days, Your Honor.
Any reason you can't vacate in 10 days, ma'am?
No, I'm actually in the process now. I just needed the time to get everything out.
All right, writ date after hearing, August the 14th. That's judgment in favor of the plaintiff. You can submit that order, sir. Okay, August 14th. Thank you, ma'am. I wish you well. You have to vacate by that date or else you're going to be evicted, okay?
Yes, absolutely.
Good luck. Thank you.
Thank you.
Thank you all. Thank you.
Thanks. South Point versus Daniel Abrams, 2502958.
Maxfield Mood on behalf of plaintiff, Your Honor.
Good morning, Mr. Abrams. Your name, sir?
Daniel Abrams.
Mr. Abrams, did you listen to and understand the rights on the video?
I did.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
I don't think I don't think that's necessary.
Counsel, give me a breakdown as to what's owed, please.
So we've got a rent to retain on this one in the amount of $1,158.80. Court costs the amount of $179, giving us our grand total here today of $1,300.
Where's the late fees? I thought you were going to give me a breakdown. That's what I was trying to ask you nicely. I don't want to. I need a breakdown. I need rent to retain, late fees, court costs.
Okay. So the rent to retain, once again, being that $1,158.80. The late fees, there was one charge in the month of July of $200. That was dropped down to $70. $130 was removed from this balance, has already been applied to this judgment. And
hang on. They're charging $200 in late fees?
For the month of July, they charged $200. They did a $100 charge on the 7th and another $100 on the 16th. It looks like they believe that there's two charges of late fees.
That's pretty good. I'm going to become a realtor. I mean, I'm going to become a landowner here. That's like 18% a month, right? The rent's that. So let's start over. Tell me what the rent to retain is. That's all I want to know right now. What's the rent to retain?
The rent to retain is $1,158.
I thought you said that included late fees.
No, that includes the late fee removed of the $130. And so it's dropping down the late fee to the $70 that you have requested here, Your Honor.
I know. So listen, so if you're charging a late fee of $70, then in my view, it should be $1,088.80 in past due rent, right? That's all I'm asking you to do is tell me rent to retain, then the late fee of, then the court costs. So am I right? The $11,858.80 includes a $70 late fee. That's what I was trying to say before. I don't want to just hear and then have to go through this on the late fees.
Okay, and so then you're absolutely correct. Prior to that $70 late fee being added, it'd be $1,000 or $1,088.80.
All right, now what is the court costs? 179?
Correct, 179.
Total amount is?
Would you like the late fee added in or no?
Yeah, the total amount owed. I want first rent to retain, $1,000 a month. They pay $1,000. Late fee $70. Court costs, including attorney fees, whatever, and then add them up. That's all I'm asking.
I gotcha. And so that gives us a grand total then of $1,337.80.
You sign a lease, Mr. Abraham, saying you're going to pay $200 in late fees if you don't pay that. You got to be careful. You got it?
I'm
just saying.
I don't know.
Do you agree that you owe $1,337.80?
With those, I thought it was less than that.
I know, but come on. There's only
Yeah,
one.
that's a lot of late fees. I didn't
Unanswered
realize it.
demand. That's the great thing about it. It requires no lawyering. None, zero. I mean, the figures are what they are. Do you have any reason to dispute that amount? If you do, tell me the exact amount that they owe you. Then we'll talk.
I have.
That you owe them, I should say. Mr. Abrams.
Yes, I'm looking at my paper. I'm sorry. Okay, so I thought I owed 1,158. Is that not right?
Does that include late fees and court costs?
I thought that, yes, I thought that included everything, but.
Well, then you give me your figures. You tell me how this turns out.
You have 1,000 what?
He says you owe $1,188.80 in past due rent, a late fee of $70, in court costs, including a $75 statutory attorney fee in the amount of $179, and adding all those up, he comes to $1,337.80.
Okay. Yes, that sounds right.
Oh, so do you understand? Do you have that money to pay?
I don't have it today. I do not.
When are
have
you
it
going
today,
to have it?
But I can have it by the 25th of this month. I can have everything.
You're asking for a lot. They're entitled to a writ date on the 14th. How much can you pay on the 14th?
The 14th. Well, I can pay at least. I can pay 600 by tomorrow. By the 14th. Yeah, I'm on unemployment. I should probably try and get funding if I only have till the 14th, because I can't pay it by the 14th. I'm collecting unemployment right now. The 25th. That's
600 by August 14th. Are you willing to give them until the 25th? If not,
that's not a problem, Your Honor.
Okay, so if you pay 600 by August 14th, the writ date will be extended until the 25th. Okay.
Okay.
So so the judgment amount is going to be $1,337.80. It's going to say right on there, and it's going to have a writ date of August 14th, but it's going to say with an asterisk, if the defendant pays $600 by August 14th, writ date extended until August 25th. You have to pay the remaining balance or vacate if you miss either one of those dates. Do you understand that?
I did. The 25th is a Monday. Can you give me until the 26th, please? That's one day. I certify on. Yes, thank you. I appreciate that.
26, no later.
26. Okay.
All right. Good luck.
Thank you. Thank you, guys. I appreciate it.
South Point versus Gilmer. Akiva Gilmer.
Gilmer.
Good morning. Did you listen to and understand the rights?
Yes, Your Honor.
You wish to speak to a lawyer?
No, Your Honor.
You intend to apply for funding?
I did, but I just recently did it a couple of days ago, and I was on the phone with them before I got on the call with you. So right now it's just waiting to know
you
whether
applied
it's
for
going
funding?
Yes, I did.
You haven't been denied or heard anything yet?
No, I talked to them this morning on the phone. I had a phone
and
call.
Just answer my question. I'm going to adjourn this to August the 18th.
Okay.
You have to provide proof that you submitted your application for funding within 5 days of today's date.
Okay, but can I ask you
Ma'am?
one more question?
Ma'am, you have to bring it up here to the courthouse. Okay? Do you understand that?
Yes, Your Honor, but I was going to ask you one more question if possible.
Go ahead.
Because that was not the initial behind the funding. I was going to see if we can reach a judgment.
Wait a minute.
Because
Did you
I
apply
had a
for
note
funding or
on my.
hang on. Did you apply for funding or didn't you?
I did, but I didn't know how fast it was going to go. So I was trying to see if I can go off of the balance that I had on my door when I came home from work Friday, which was a balance of $706.27. And I was trying to see if I could pay that Friday because I will have that by Friday.
Is that what she owes, Mr. Mudar?
No, that's not incorporating August rent, unfortunately.
That doesn't have August rent, ma'am.
Oh, okay.
Listen, I'm adjourning this to August 18th. Jennifer, at what time?
9 o'clock.
At 9 o'clock. You have to provide proof that you've made application for funding within 5 days.
Okay.
If you do that, we're going to come back the 18th and find out what happened. Okay? So I'm adjourning this date, August 18th at 9. You have to submit proof to the court that you've made your application for funding within 5 days. Do you understand that?
Yes, Your Honor. Do I bring it up there to you or how do I?
Not to me, to the civil department, correct.
Okay.
Okay? Good luck. South Point versus Robert Johnson, 2502965. Mr. Johnson, name?
Your Honor, I have not had Mr. Johnson check in.
You can take a default on this one, counsel.
Max Field Mudar on behalf of plaintiff, Your Honor.
Go ahead.
You've done cement work in the past.
Yes, sir.
You've got certificates in welding and material handling. What's material handling?
Material handling as well. Like shipping in, receiving in, shipping out.
Okay. Okay, the pre-sentence report is reviewed and made a part of the record for all purposes. Go ahead. What is the state asking for?
Your Honor, the state is asking for a 5-year TDC. Again, the sex offender registration requirements are there to protect the community. We know how serious these offenses are, and believe the defendant's been given a break by being given the cap here, and so we believe the 5 years is fair.
Okay. What's the defense say?
Well, Judge, I clearly disagree with the position of 5 years TDC. We are here asking you for probation today. He is very aware of the mistakes that he made that led him to the position that he is in now. He has accepted responsibility for those active decisions to evade his responsibilities. He knows that those are responsibilities that he will have to ensure are taken care of if he is put on probation. And he is positive about his ability to be successful in doing that. He has support on the outside. His family is from this area. He will have a decent paying job to help him work through probation and to ensure that he is successful at these things on the outside. So we are asking for probation from him, for him, Your Honor. Do you have anything else that you want to say?
Sure. All right. If nothing further, I'm going to find as follows then that Mr. Freeman, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty to this third-degree felony of failing to comply with sex offender registration. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt here. The battery died. I mean, there's nothing else that can happen to that machine I'd be shocked. There's everything that could happen has happened on that machine. And so there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third degree felony of failing to comply to sex offender registration. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement in prison. I just want you to let that soak in for just a moment. You understand where you stand here on all of this. You've got 117 days credit. That's far short of being able to be paroled. You'd have to stay in there a long time. Now, what we're going to do is grant your attorney's request. I'm going to suspend this, place you the confinement, place you on probation for 10 years. Do well, it'll get shortened. But you have a lot of requirements to do in this probation, not the least of which is make sure you are always properly complying with the requirements for sex offender registration, and because that'll get you quicker revoked than anything else. Also, there will be terms and conditions of probation, which are normal and customary for this type of offense. And you will register with the sex offender tracking program. You will also enter and successfully complete a moral recognition therapy class, which is a good thing all the way around for all people. But you and I both know what the background of this case is and why you were registering as a sex offender. And we're not going to, there's no reason to ruin everybody's day about it, but it's not a good thing. That was in the past. What's in the past, though, it said is never really ever in the past. You got to deal with it on situations such as this. Also, you must understand that this is a conviction here, even though you're not going to prison. This is your second felony conviction. Third one is catastrophic for people. So you've got everything to work for in successfully handling this probation. Get this back on the deferred. Give it to Rogan so she can shred it really fast. Well, that one probably do more harm, I would think. That deferred, if you will revoke on that deferred, you'd be looking at up to 20 years in prison. So this, you're capped at 5 years, but nonetheless, you know what it's like. And this gives you an opportunity to take care of concrete work, get a trade, follow the rules, and stay out of trouble. Are you going to be able to do that? Good. All right. Just don't talk the talk. Good for you. Walk the straight line. All right. Please, we're gonna get your thumbprint, then please see the probation officer. Thank you.
Say 2 more times, just anywhere.
Next, you want to take up?
Harris, Nehemiah Harris. Judge, this is clearly an old case, but
I'm an old case.
she was not in the county until recently, Judge. I'm still working on getting her discovery in her media and talking to Mr. Boyd. If I could have 2 to 4 weeks to get everything ironed out.
All right, we set 3.
Yes, 3 weeks. Thank you. It's an empty enough change, you know. Yes, I have not, I don't even have a formal discovery just yet. Okay.
Colton Fall.
We were holding him, Judge. I need to go through some paperwork.
Okay, and Kendrick Franklin.
I'm still talking to Mr. Boyd about that one.
And then I've got Heather Lane.
Yes, Your Honor, she is new to me. I still don't have her media. If I can have 4 weeks on her,
You
please.
got 4 weeks resetting on Heather Lane, 25 CR 655. Benjamin Leonard.
Same thing on him, Judge. I
You need
need
some
2 weeks for media.
Okay. Blake Ritchie.
I need to hold him. That one might be a potential plea today as well,
And
Judge.
then
And then we have Keith Pruitt.
finally, we did Christopher Smith already.
Yes, that's correct, Judge.
What?
Keith Pruitt, he's the one with the letter from the Texas Health and Human Services. We need to
Okay.
make findings for him.
All right. Do we need him out right now?
I don't think he's not here, just not here.
It's not favorite, Judge.
You'll have to put on the record.
All right, let me put this, here it is. We now call 236015, the state of Texas versus Keith Andre Pruitt. Ms. Manalden, defendant's attorney, is present. The defendant is not here. Do we need him here in person on this particular matter? All right. Can you summarize here on the record what we're going to do? Because I have in the file received a letter from the Texas Health and Human Services Commission dated July 3rd, 2025, a month ago here, regarding Mr. Pruitt. And essentially, they're stating that the defendant needs continued ongoing inpatient treatment toward regaining competency, and that's why we haven't moved him around the country.
That's correct.
We're keeping him in that place because that's where he is progressing, apparently, according to these authorities. It states here in a letter from Sylvia Trevino and also signed by Sonia Hernandez Cagle, the trial competency analysis is Ms. Trevino, and then Ms. Cagle is the superintendent at Texas Health and Human Services Commission, and they have the cover letter requesting additional time of treatment for Keith Pruitt. And there is a 6-page trial competency evaluation that is attached to this cover letter. And I'm going to call the cover letter dated July 3rd, 2025, and the 6-page competency evaluation report, Court's Exhibit 1 for this hearing. Any objections?
No, Judge.
No, Your Honor.
Do the parties want to add anything to the record here?
No, Your Honor.
No, Your Honor.
All right, in summary, the convicted of anything before?
Yes, sir.
You have? What was it?
Controlled substance.
Is that all fixed?
Yeah, yes, sir. Everything's just good. This is the
All right.
fix.
All right, well, fix this one.
Yes, sir.
Okay.
Yes, sir.
All right, sir. Please see the probation
Thank
officer.
you.
Thank you.
Thank you. Thank you. Good luck, man. Yes, sir. Appreciate it. Thank you.
You know what's bad about this pad is these pads, it's the curse of the left-hander because of the way I write, if you put your hand
Heat from your hand.
on the pad, it'll smudge the pad and.
You gonna have to change directions.
Yeah, okay.
The other guy,
That was Mr. Ramsey. You have Jay DeVillier?
he's ready.
Jay DeVillier, please.
And he just needs to be fingerprinted.
Okay.
Okay. He's good. He's good.
We didn't have that, but I don't know if we asked them, but no. There they are, in case you go out some notes down, we get files, we do some of these. Okay, all right, this. Yeah, thumbprint?
Yeah, please.
Really good discussion that one.
Same stuff anywhere.
Good on which one? Richie. He's ready. We now call 25 CR. Right there, sir. 25 CR 729, the state of Texas versus J. Kenneth Deville. You are Mr. Deville, present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Hold on for a second.
So let's do.
The Dell ones are finally gonna be here.
So those is going to the jail, huh?
Well, I don't know. I kind of feel like we should.
Because you keep company with people that just, it's incredibly concerning to me as a woman and a judge to watch you look worse every time I see you, look more beat up than the last time I saw you, and to continue to pick up cases and.
That's your hand.
I know, and
I'm probably gonna go back to my baby daddies after I get out.
I can't write without putting my hand on it. Okay, I figured it out. Well, out with the machine. One way or the other. How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? Yes. You have to speak out. So she can. Yes. Okay. State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement, if nothing further. I'm going to find you, sir, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes,
there's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt right now. I am not going to do that. I'm going to rather place you on deferred or unadjudicated probation and postpone any finding of guilt so long as you follow these terms and conditions of probation. They're normal and customary for this. Fix this. We can release you from these requirements in a third of the time. But if you fail, which is, I hate talking about this, but I have to tell you, if you fail, your probation could be revoked.
Yes, sir.
You could then be found guilty and sentenced for this up to 20 years in prison. So there's a lot on the behavior writing on this. Fix it. All right. Anything else to add by anybody?
That's it.
Okay, please see the probation officer. Good luck.
Hey, Judge, on Mr. Herring, I just want, no, he's not Mr. Herring. You can good luck. I just want one week on him, and I'm gonna try to work that out. I just need to investigate a little bit more. So I just had 3 today. He's the middle base.
Mr. Deville. Okay. Nathan's Herring, how much time?
This is normal 4 week.
We don't have anything normals here. Is 4 weeks good?
That's cool.
Okay.
Yes. And then, domestic violence second? Yes. So you understand, Ms. Patton, on that, is this assisting, resulting in assisting, no, listen, resisting, assaulting, and obstructing an officer is being reduced to attempt. So it would be up to a year in jail and a fine of up to $1,000. Do you understand that?
Yes.
And then the domestic violence was not written as a second.
She wanted medical attention.
Hold on.
Yeah, I don't think it was written as I don't
Like
think it's
my
in
lawyer
the
said.
information
My other
as a
lawyer
second
said.
offense. Let me see, but I don't think it was in the information, Judge, as a second.
It wasn't. She wanted me to get medical attention because of my alcohol.
Hold
problems.
on, just Ms. Patton, no talking for a second. Let us figure this out, okay? Can I get the prosecutor in here?
Yeah, the count 2 is just the domestic violence.
And she's amending it to a DV2 for the plea?
That, yeah, let's ask Ms. Silk about that. We might need clarification on that.
Yeah, because if I'm reading this right, I ever treated you unfairly?
Never.
All right, we'll work those things out, okay? Let's get your plea on. We'll figure out, we'll figure all of that out.
Okay, sounds good to me.
Okay, I mean, but let's get to the point where we have to. So they'll send you down to probation. I think she'd do great in treatment court, honestly. And she might be assessed and they might recommend it.
Okay. So Judge, that is, so we were going to do a no contest plea. I did speak with the officer and the prosecutor. They both agreed to a no contest plea, considering the state that Ms. Patton was in at the time of her arrest. And I don't know if that would affect the treatment court.
Well, to tell me to listen to what I'm telling you. Ms. Segura, are you gone this afternoon?
No, Judge.
You're here?
Well,
all right.
not in the court, but I can come back.
Okay, because she's got to talk to her if she's taking, I mean, it's either being waived, we're holding an exam, or she's entering a plea, but unless you talk to the prosecutor, but I am certainly not taking a plea from someone who says they're not guilty.
I understand. Judge.
So I'm going to give this file back, Ms. Patton, listen.
I'm gonna be in rehab, so.
Okay, no, listen. Ms. Segura's going to meet with you. I'm coming back at 1 o'clock and we'll handle it at 1.
Okay.
But you have to listen to your lawyer. Okay.
Okay, thank you. I'm sorry. I can't hear him and
It's okay.
It's okay, Miss Patton, take a breath. Take a breath. Let's get you some treatment, okay? Get you some help, but you have to take the plea, or you have to talk to your lawyer, or your lawyer has to talk to the prosecutor, or we have to have an exam. Something has to happen today. So talk to Miss Segura. I'll see you back at 1. Okay? All right. All right. We're on break until 1.
Defendant was sentenced. I set a prosecutorial review date. It should have been March 25 to 26. But at any rate, I ordered him to serve 5 days on the court work program and pay $35 per day. I set a beginning August 2nd review date on July the 30 at 8:30. Pursuant to the plea agreement, there was an agreement that the defendant must register and obtain licenses for all animals in the home within 30 days. I also ordered that the dogs remain in the defendant's residence or in a fenced-in yard or on a leash when outside with a lead. This charge of failure to provide proof of animal license was issued on June 30. We were in here July 16th. Mr. Adams said he wanted to hire a lawyer. And that's where we are. So do you wish to have a hearing, or do you wish, is he going to plead guilty? Ms. Tessino, your name. Does he wish to hire, does he wish to?
He asked me, Your Honor, just so you know.
No, I know.
You're asking a different question.
Go ahead. Or does he wish to have a hearing?
What are we pleading to or not pleading to, Your Honor?
Either guilty or not guilty to failure to provide proof of an animal license by May the 4th, which is what I ordered.
Your Honor, he did not have proof of a license by May 4th, but I can give explanation of what was going on.
So is he going to plead guilty, or does he wish to have a hearing?
Regarding whether or not May 4th, if we're just talking about May 4th, I think the court knows, and my client would admit that he did not have a license on that date. But can I say guilty with an explanation?
Well, you're always going to be able to give an explanation.
Well,
if you plead guilty, sir, I want you to understand you could get 5 days in jail on this. Do you understand that?
I do understand.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. At a probation violation hearing, you have, why don't you two come on up to the podium if you would, please. At a probation violation hearing, you have the right to remain silent. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that, Mr. Adams? Mr. Adams, do you understand what I just said?
Do you understand what the judge said?
And you wish to plead guilty?
Well, guilty with explanation.
If you plead guilty, I'm taking your plea and I'm going to listen to your explanation anyway.
You will listen to it?
I will listen to it.
Sure, guilty.
To the charge you failed to obtain proof of an animal license by May the 4th of 25. How do you plead?
Guilty.
Did you fail to provide proof of obtaining an animal license for your dog by May the 4th of 25?
Yes.
Anybody force you to plead guilty?
No.
Plea is accepted. Have you filled out that and submitted that?
I just want to get the right, I can't remember if it's the city of Woodhaven, the city of.
This is Brownstown.
Township.
I need your appearance. I will accept the plea. Nobody's forced you to plead guilty, correct, sir?
Correct.
All right. Mr. Mullins.
I have it right here, Your Honor.
I want to remind everybody that you guys signed an agreement to obtain a license from the township. That was on the plea agreement. You can hand that up. That was on the plea agreement. That was what I ordered at the time of sentence. It still has not been done as far as I can tell, unless it's been done in the last 2 weeks. He's got a license?
He does. And Your Honor, look, I understand that whole license and registration. Can I speak now, Your Judge?
Sure.
I don't want to cut anyone short.
Did you, hang on one second. Did you see that license? I did.
I just got it. I think he dropped it off on Friday. I was off. So I now have proof of it. I got it today and I let her know.
And I confirmed with animal control that both dogs are now licensed, Your Honor.
Okay.
Your Honor, this was a troubling situation for Mr. Adams, only in the sense.
If he's got the license, I'm not gonna make a big deal.
Okay, I'll shut up, Judge.
I'm not gonna, that's all I want. Now, you have to understand, I cannot let a dog that hasn't had rabies shots running around the township. I can't let that go on. I can't let that go on. Even though you're disrespectful from time to time, I have no problem with you personally, Mr. Adams. I really don't. You think differently than I do about the government and all these other things, but I don't have a problem with you personally. But you can't let your dog run all over the township. I've tried to say this nicely 14 times to you and your wife. If you want to let your dogs run, buy all the houses, fence in the yards, get the township to change the zoning. You could have 148 acres. They could all run around. You could have 49 dogs. One of those dogs bites a kid. This is the least of your worries. And these are not little mutts that aren't going to inflict harm. What do you want? What do you want me to do?
Your Honor, I, as it relates to the license, I have no position now that Mr. Adams has gotten the license. We were just looking for compliance.
I know. So was I.
I tried to do the right thing, tried to license him without trying to make sure that he's, just don't want nothing to happen to him.
Nobody wants anybody to happen to anything. Dogs, kids.
Yeah, I know.
Adults.
I know. If he was unsafe, I would not even happen.
Has he been otherwise compliant as far as you can tell?
Well, there has been, I've just got a video to load, that there was, the victim submitted a video to Caitlin that the dog was, one of the dogs, the black one, which was running on his property on July 31st.
Wasn't his.
If I may, Your Honor, they dispute that one or both of those are their dogs. So what I had animal control do, they sent them over to the street to see whose dogs it may have been, and ask the complainant for additional footage to show where those dogs came from. So I don't know if you want to have a separate hearing scheduled for it. In the interim, animal control can do some legwork on it.
Your Honor.
Well, the whole thing would be, did it violate a law, right? So you almost have to, the probation department can issue a show cause for violation of law. You can issue a complaint or a citation for violation of law. And then if that happened, and I'm convinced it's their dog's, his dog.
Just so the court knows, we looked at the photograph as well as the video, and immediately I stated that's not my client's dog. It does not look at all like my client's dog. It looks like a different breed of dog. It's not such a great video that it's discernible, but my client.
Why didn't he just do this before?
You know, sometimes, Judge, people have different views. And you know what? We're not always saying that they're right or wrong.
You guys signed an agreement and I ordered that the dogs be licensed. And how could they be licensed? In only one way, as a condition precedent. That is, right? The dog had to have its shots.
Your Honor, can I say this? In looking at the whole issue, we're going to look at this issue with the vaccination. There is a movement now, Your Honor, that vaccination is, now it's not the law. You're not obligated. But I will say this, in looking at this, because now I had to get my nose up in this, the technology that was available at the time, 80 years ago, with the mandatory rabies vaccination law that went through that we're under our state, they didn't have the ability through measurement and science to do the type of testing that Mr. Adams had requested, which is to be able to draw the blood of the dog, which he did, have its blood analyzed by a veterinarian, which he did, and sign off that there were sufficient antibodies left in the system in order to combat any type of.
Can I ask a question? When did the dog get vaccinated, and has the dog experienced any adverse reactions?
You got on the 31st.
So 4 days ago, any adverse reactions?
He's starting to, he just hasn't eaten, and he, like this morning, he was in sweats.
You can't ask judges just to ignore laws, Mr. Mullin. I mean, it might be that they should, maybe you should call the legislature. You can call the legislature, get them to change the law, but until the legislature changes the law and the township follows suit and changes the law, this is the law.
Your Honor, there have been some communities that have allowed.
That's fine.
They just didn't, they looked at it in this community, they decided not to go with it, he got a license.
I don't know how they can, well, whatever. I don't know how they can override state law, municipality, if they think, whatever. I'm not getting into that. Look, he pled guilty. Is there anything else anybody wants to say? I'm gonna call this a technical violation. He's gonna pay costs of $125. If you object to that, have at it. If he wants to say anything else, have at it. If you want to say anything else, have at it.
I'm not saying.
All right, good enough. Anything else, Mr. Adams?
No, sir.
125. This is not personal. You forced me to bang my gavel twice last time you were in here. You know how many times I hit that gavel? I had law day, and these kids come in and hit it 200 times. I got 300-400 kids that come in here. I've hit it 7 or 8 in 30 years, twice with you here the other day. Knock it off. Good luck. Have down and pay.
One time for you, Judge.
You're gonna
30 years ago. I'll see you around.
Take care. I need everybody to stay seated. Who?
In regards to other cases based upon the defense statement. So I'm not making a finding in that regard. So you're on non-reporting probation as of today. You need to contact the clerk of the district court, make arrangement and find out how you need to pay these things off to get this taken care of. So that is for 1 year or 12 months. Non-reporting. And I strongly encourage you to write down when you need to get that paid off by, so that you don't get, forget, or don't forget. All right.
Yes, Your Honor.
Now, there may be sanctions that the DMV will take on your driving privileges based upon these convictions. Be sure that they have a current address for you on your license and so forth, because those don't get forwarded. Anything further on this matter today?
Your Honor, besides the scheduled and statutory minimum fines, is the court also ordering court costs in this matter?
I ordered court costs, yes.
Very good, Your Honor.
There's nothing further. The Pfizer matter is adjourned and the parties are free to go. Mr. Patterson, are you ready on your case now?
Yes, Your Honor. Priscilla Ursery.
Bring Priscilla in.
This is State of Kansas versus Priscilla Diane Ursery, case number 22 TR 1821. If counsel would state their appearances, please.
David Lowry on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Priscilla Ursery, who does appear from Courthouse Security 1 video station. Judge, in this case, I've talked to Miss Ursery. We're requesting the case be set for jury trial with pretrial September 29. And Judge, can tell the court a representative of Second Chance Bail Bonds is also present. They're in agreement to continue Miss Ursery on the bonds. We'd ask the court to reinstate bond, allow it to continue.
Okay, where is the bonding company right now?
Right here, but
Right here, you know,
Okay, and the company you represent, sir?
Second Chance.
Is there a motion? Was there a motion to set us or in regards to bond at an earlier time? Was there a failure to appear or anything to that effect?
Your Honor,
Yes.
this is a case where it does appear there was a failure to appear back in December of 2024. Prior to that, a failure to appear in October of 2022. So this case does have a certain degree of age to it. I am showing that a motion for judgment on bond was filed with the court in February of this year.
Okay, and what was the resolution of that bond or of that matter? Are we supposed to address that today?
That the state's records indicate the motion was to be taken up at today's setting, Your Honor.
All right. What's your position in regards to the motion for forfeiture of the bond then, Mr. Regier?
Your Honor, on the limited issue of the motion for judgment on bond itself, based off the defendant's appearance here today, the state would move to withdraw the motion. The state does not offer any recommendations insofar as the court's prior orders following the defendant's failure to appear back in December of 2024.
Mr. Patterson, any statement in regards to the bond issue?
Judge, just again that the bondsman has agreed to carry her on the bond. We'd ask the court to reinstate bond and set the case for jury trial.
And sir, I'm sorry, I didn't catch your name earlier, the bondsman.
Willie Davis.
Mr. Davis, I'm going to not forfeit the bond at this time, but Mr. Davis, my position is professional surety bondsmen, when they're agreeing that people are going to be in court, and if they don't, I don't like continuing those matters and so forth. If you're willing to stay on the bond, that's fine. But if she doesn't appear and there's no other appearances on there, the bond will probably end up being forfeited.
Okay.
Not just extended for indefinitely, that sort of thing. Like, so I'm not familiar with you, but some bondsmen seem to think that it just needs to be continued forever. So I'm not of that view. So Ms. Ursery, your next court appearance is September 29th. You are to appear there at the courthouse security.
Is there any way that I can do the Zoom? Because I live in Wichita, Kansas, and it's...
Well, ma'am, when you failed to appear before and you're asking for a jury trial, no, I want you there.
Okay, I understand.
I want you there. So September 29th at 9, your jury trial, counsel, is that October 1?
Yes, Sean.
Okay, the jury trial is set for October 1. And that's for 2 days. You need to stay in contact with Mr. Patterson. Be sure that he has a way of contacting you. Because if you don't show up at that on the 29th, from what I've seen of the other judges, is probably is going to be a no bond hold issued against you, and you miss your date of your trial for October 1st and 2nd. You may be sitting in a cell for a long time if you're not there then. Okay?
Yes, sir.
Stay in contact with Mr. Patterson. If the case gets resolved, you need to follow his directions about when and where to appear. All right?
Yes, sir.
All right. Any questions on it from any of the parties?
Your Honor, is the court issuing a ruling at this time on counsel for the defense's oral motion?
Which is
Reinstate bond, I guess, Judge.
the second chance bonds indicated they will stay on the bond, so I will reinstate it. But they've also both the bonding company and Ms. Ursery have been warned in regards to the likely results if there's another failure to appear. So,
Thank you, Your Honor.
anything further on Ms. Ursery?
No, sir.
No,
Very
Judge.
well. With that matter, we are adjourned.
Thank
Parties are free to go. Do we have anybody, Mr. Patterson, you have anybody else?
My last case is Winter Daniels, and I just wanted to verify again, Jen, is anybody in the waiting room?
Judge, yeah.
No.
Okay, then that's a non-appearance.
Okay, this is State of Kansas versus Winter Daniels, 25 CR 254. Counsel to state their appearances, please.
Jerry McGee on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Winter Daniels, who does not appear. And Judge, did we take this one up already? I'm trying to.
Well, I remember was trying to call it earlier, but we may have set it back. I don't recall right.
We did take it up, Judge.
Okay, then I just didn't get good notes, Judge.
I
can't remember what happened now either.
This case was set over to August 11th.
Oh, that's right.
I remember that now. Okay, yeah, so
that's my last case, Judge. I have nothing further.
Okay, so that's been dealt with. So everything is set back to that was it October 11th or September the 11th?
August.
August the 11th. Well, 0 for 2 there. Okay.
And Your Honor?
Yes.
Before counsel for the defense departs, the state would request leave to go back on the court briefly in the Stamper matter, 24 TR 3085.
Mr. Stamper here.
He's the one in Sedgwick County Jail, Judge.
Okay. We'll readdress that issue then as that's his counsel may proceed on that.
Yes, Your Honor. And the state's understanding is that that matter had come before the court on a motion for judgment on bond, and the state understands the court had already ruled on that. In accordance with my duty of candor, although I don't know if this changes the court's rule or not, my office has confirmed that counsel for the defense's statements regarding the defendant being incarcerated are accurate. But I'm merely advising the court as to that per my duty of candor as an officer of the court.
I appreciate that, Mr. Patterson.
I don't have any new information, Judge.
Okay. I'm not going to adjust my ruling.
Very good, Your Honor.
All right.
Judge, I think that was it for me. May I be excused?
Yes, you may. Mr. Davis, was there anything you needed to cover?
Yes, we I had another Mr. Keeler, Bryce Keeler.
That's 24 TR 3434, Judge.
Okay. This is State of Kansas versus Bryce Keeler, 24 TR 3434. Counsel to state their appearances, please.
Jerry McGee on behalf of the state.
And any other defendant, Mr. Keeler does not appear, nor is there counsel for him. I think we may be here on the state's motion for forfeiture of the bond. And Mr. Davis is here apparently for second chance bonds.
Yes, sir.
And Mr. Regier, I'll hear you first on your motion.
Yes, Your Honor. This is a case where a motion for judgment on bond was filed with the court on May 16th of 2025. The attached notice of hearing appears to be for today's date, and time includes both the bondsman and the defendant at a local address. I do have a note in my file that would appear to indicate there was attempt at service of certified bail back on May 20th of 2025. However, at this time, I am not aware of any returns of service on the motion for judgment on bond on file with the court at this juncture. So the state will defer to the court as to how it wishes to proceed.
Okay, so there was a failure to appear on May 16th, is that correct?
Your Honor, the state's records indicate that the prior failure to appear occurred on March 10th of earlier this year. It does appear that previously an appearance bond for that date and time had been executed in the amount of $2,000 professional surety.
Okay, Mr. Davis, is there anything you'd like to state on behalf of Second Chance Bonds?
Yes, sir. We just requesting more time. He has been seen, but the opportunity to pick up hasn't presented itself due to either waiting on backup to come and he got away by the end. It's been a couple times we've seen him. So we just requesting a little bit more time. I mean, as much time as you're willing to give us.
Now, you've had since March 10th when he failed to appear. I'm going to grant the state's motion at this time. If he's produced, the judge may wish to readdress that, but I'm not going to grant any continuances or extensions. I'm going to order it at this time that the bond be paid. Again, if you produce Mr. Keeler, the court that you're in front of may be inclined to do what you're requesting, but I'm not going to at this time. So, okay. Anything further?
Not from the state, Your Honor.
Very well. This matter, the Keeler matter, is adjourned. Anything? Mr. Mendes has been here patiently waiting, so let's take up his case. State of Kansas versus Kenny Mendes. Case number is 24 TR 3218. Counsel, state their appearances, please.
Jerry Regier on behalf of the state.
And you are Kenny Mendes?
Yes, Your Honor.
And Mr. Mendes, do you have an attorney?
No, self-representing via Zoom video call.
Okay. Counsel, all I have is set for a hearing. Where will we stand on this matter?
Your Honor, this is a case where it does appear that the matter was originally heard before the court in January of 2025, and the matter was continued after the prospective possibility of diversion was discussed. I'm showing that the defendant failed to appear at the subsequent hearing in May of 2025, and the court issued orders in accordance with that. In the interim, it does appear that a diversion application was received and approved by my office. And the matter was continued from a May 30th setting before Judge Ward to today's date and time for purposes of finalizing diversion. Based off the notes in my file, it does appear that a diversion agreement was circulated by my office approximately 2.5 months ago. However, I am not aware of any diversion agreements actually been filed with the court at this time.
Mr. Mendes, are you wanting to pursue the diversion? What's happened?
Yes, Your Honor. I'm requesting an extension for the diversion. I called the office last Monday, July 28th, asking to pay on Friday of last week, August 1st, waiting for a paycheck so I could finalize the payment for that. Then I tried to pay on Friday and via the portal, and I was running into some issues not letting me pay or anything. So I was just wondering if I could get an extension. I could take care of that today. I have the money.
Well, how much are we talking about that you need to get taken care of?
It was around like $400.
And is the state still willing to be doing the diversion at this juncture?
Your Honor, I do not have any notes from the diversion coordinator one way or another at this time. What I would tell the court is if the court does determine to set this matter over, the state will be objecting to any additional continuances. Besides the number of settings of this case, this is a case that is getting a significant period of age to it. The ticket does appear to refer to a stop occurring approximately 9 months prior on November 30th of last year.
Mr. Regier, you're here for your office, so you're the representative I need or you need to tell me if your office is still willing to do the diversion or not. If you're not, then I need to set different matters. If you are, then he can make his payment and try to get this thing done. But I need to know one way or the other how the state's position.
Your Honor, may I request a brief 1-minute recess to review this matter in greater depth?
Very well.
Thank you.
Jen, do we have any other cases?
Let me check, Your Honor.
Okay.
I'm showing we still need to take up Damian Nathaniel Green.
Is that the only one?
That's the only one I'm seeing.
Okay, thank you. All right. We're back on the record. Mr. Regier is returned. Mr. Regier?
Yes, Your Honor. I have had the opportunity to confer with my colleagues regarding this matter. The state at this juncture is prepared to continue this matter over one final time for the purposes previously stated on the record. However, the state will be objecting to any additional continuances if it comes to that.
Okay. So the state is willing to allow him to proceed with the diversion.
At this juncture, Your Honor, but again, if the matter is set for another hearing, the state will be objecting to any additional continuances.
All right. Mr. Mendes, they're saying that you can still do the diversion, but you need to get that done right now. By right now, I mean you need to get that done today.
Yep.
This has been extended too long. So what I'm going to do is I'm going to set this matter for trial. That trial date is going to be October 27th at 9. If the diversion is entered, then that case will be removed and it won't be on there. But basically, you're not. I want to proceed, get this case wrapped up one way or the other. If you get it done like you're saying today, fine. If not, come October 27th, the matter is going to get tried. Okay?
Yes, Your Honor.
And Your Honor,
I strongly suggest that you get that taken care of today. So, because if it's not, the state may both parties, neither party is required to go into a diversion. So that's their discretion in that regard. So you don't want to push the matters any further. Mr. Regier, do you have something else?
Yes, Your Honor. If the court is determining to set this case for a bench trial, the state understands that Judge Webster traditionally hears such matters on Wednesday afternoons at 1:30.
Jen, what's the next trial date that's open?
If you would like bench trial, that would be September 24th at 1:30.
Okay, let's set it for September 24th at 1:30. Mr. Mendes, that's your next court date. If necessary, if the diversion paperwork is filed with the court, then that'll be removed. Okay?
Yes, Your Honor.
Any questions?
Yes, I'll take care of that right after this court.
Okay.
Do I go to the attorney's office to sign and pay for everything, or where do I go for
Mr.
that?
Regier, where does he need to go?
Your Honor, if the defendant wishes to reach out to my office in person, I believe my office will be in a position to point him in the right direction.
Okay, who is it he needs to speak with?
Your Honor, the state understands that the diversion coordinator in my office is Miss Christina Bastain.
Christina
Bastain, Your Honor.
Bastain?
Bastain.
Bastain. Okay, Mr. Mendes, you need to contact the county attorney, Butler County Attorney's Office, and ask for the diversion coordinator, and she can probably answer any questions that you have on this. Okay?
Yes, Your Honor. Thank you.
Very well. This matter is adjourned and the parties are free to go. Okay, Mr. Regier, while you were out, I asked the clerk if we had any other matters, and the only one she could see that we still had on the book here was State of Kansas versus Damian Nathaniel Allen Green, case number 25 TR 321. I'd ask for appearances on that matter.
Jared Regier on behalf of the state.
And does Mr. Green appear with court security?
He does not.
All right. And Jen, has there been anybody on and off or waiting on Damian Green?
No, Your Honor.
Very well. I find that Mr. Green fails to appear. Counsel, what it said this was a bond hearing. What were we to address today?
One moment, Your Honor. Your Honor, based off my notes, I am showing an appearance bond was executed for $1,000 on recognizance for today's date and time. I am showing that the defendant appeared when this matter was previously before the court back in May, and the matter was continued to today's date and time, seemingly based off my notes, for the defendant to hire representation.
Has your office been contacted by an attorney to your knowledge?
Not to my knowledge, Your Honor.
And does the court file reflect an application for court-appointed counsel, Jen?
One moment, Your Honor, I am looking.
And Mr. Regier, what's the Mr. Green charge?
I do not see an application for court-appointed counsel.
Okay.
And Your Honor, count one of the information in this case appears to be one alleged count of no proof of insurance, a Class B misdemeanor. That appears to be the sole count before the court in this matter.
All right. So Mr. Green appeared before and asked for a continuance to hire counsel, and apparently has not been in contact nor counsel on his behalf. Is that right?
That would appear accurate based off the state's records, Your Honor.
All right. I'm going to order a forfeiture of the bond. I understand that's an OR bond, but I'm ordering forfeiture of that so there can be a formal motion filed by the state. Additionally, I'm going to issue a bench warrant for failure to appear, and I will set a cash or surety bond of $5,000. And a condition of that is Mr. Green, if he posts that bond, is to appear in person at the courthouse, not via Zoom. And then the standard conditions of probation, a bond for misdemeanor offense in Butler County also will apply, but a special condition is he must appear at the courthouse. Very well. Anything further on Mr. Green?
Not on this matter, Judge.
All right. That concludes State versus Green. Are there any other matters that either the clerk or Mr. Regier that you have listed for today, or if court security have somebody else show up that we don't have?
Your Honor, the state is aware of one final matter.
Okay. Al, do you have anybody else showing up?
No one else is here.
What, Mr. Regier, what's the final matter?
24 TR 2037, Your Honor.
Case name, please. I don't have the.
Last name Sewell, Your Honor.
With an S?
Yes, Your Honor.
I'm not seeing, how's that last name spelled?
Sewell from the state's understanding, Your Honor.
I don't see him on the docket. Jen, do you have that, or do you know, can you pull that matter up at all? She may need a case number, Jared.
Yes, Your Honor. 24 TR 2037.
I do not have it on the docket. I am looking at the case to see why it would have been scheduled for today.
Okay. Maybe it's another date, so.
I show an unserved motion for judgment on bond. It was supposed to be scheduled for today. Jared is correct.
Okay, so he was picked up on a bond and given today's date, fails to appear?
Your Honor, as a preliminary matter, this is a case where it does appear there's an order appointing counsel with respect to Mr. Patterson. Although the fact that Counsel Patterson is no longer present in this docket apparently does complicate matters somewhat.
Well, the
On the
defendant
Google
doesn't
Pixel, can I
show
get
up
your
in
name,
his
please?
bond sheet, had him
On mute.
scheduled
There
for
you go.
today.
Hello?
Did
Can I get
you
your
have
name?
it?
This is
Anybody
Jason
have a
Herndon and
different
Tyler
date
Herndon.
on him that perhaps with Mr. Patterson
What are you
was
here
advised
for?
of?
Your Honor,
A eviction hearing.
what I would tell the court
You
is
were
again,
scheduled
while
at
it is always the
11:30.
state's preference to proceed in the presence of counsel for the defense, the
I know
motion for
it took a
judgment on
few
bond does
times. We had
appear
to
to
get the
include
numbers. It
a
was like
notice of hearing
they
of
wrote
today's date and
the
time and does appear to refer to
Zoom
both
meeting and the
counsel for the
time is all they
defense
really
and
scribbled
the
in, but
defendant. I am showing a return on that
Okay,
same
well, they
motion.
rescheduled another
It does
hearing for the
appear to
18th at
include a
8:30 in the
notation
morning.
stating, quote, return to sender,
okay.
unclaimed,
Okay, so
unentered
write that
forward,
down.
and an
18th at
affidavit
8:30
of
in the
service
morning.
by certified
Hold
mail.
You can
on
come
one
to the
second.
courthouse
Certified
if
mail
it's
receipt
easier.
number with respect to the
Okay, what date
defendant.
was it? 18th
Jen, did you have
Correct.
anything further?
at 8 a.m.
8:30 a.m.
And is there another
I am
Zoom?
showing the
If we
same
want to do it
return
on
that
Zoom, is there
Jared.
another Zoom ID?
It doesn't change. Same Zoom
Okay.
ID.
Okay, what is the
18th
charge
at
on
8.
this?
All right,
working on
thank you.
it.
You're welcome. Bye.
We got it done.
Okay.
Work shit on.
Yeah, we gotta keep moving them. Oh, well, these are all hers.
Oh, yes.
Please.